want to call to order the regularly scheduled meeting of the Littleton Planning Commission for Monday, June 11th, 2018. May we please have the roll call with names. Thank you.
Commissioner Coronado.
Here.
Commissioner Reynolds.
Here.
Commissioner Stallman.
Here.
Commissioner Rennicki.
Here.
Commissioner Bolt.
Here.
Commissioner Swartzbacher. Here. Commissioner Breitenbach.
Here.
Commissioner Almond. Here. And Commissioner Miller is absent tonight.
Okay. If you're looking to the board in back of you, that's City Council. We are the other people. Planning Commission. Let's see, next on the agenda is the approval of the agenda. Anybody have any changes they wish to make? Seeing none, we'll move on to minutes of approval. That's the PC meeting from April 23rd, 2018. Do we have a motion or changes?
I move to approve the meetings.
We have a second.
Second.
We have a motion and a second. Please vote. You want to do it by roll call?
Sorry, yeah, because your names aren't up there.
Sorry, you're right. Now, go ahead. Old school.
Do old school. Commissioner Coronado.
Aye.
Commissioner Reynolds.
Yes.
Commissioner Stallman.
Aye.
Commissioner Rennicki.
Aye.
Commissioner Bolt.
Yay.
Commissioner Swartzbacher. Yes. And Commissioner Breitenbach. Okay, it's unanimous and the motion passes.
No, thank you very much. Old school still works. Barely. Next item is public comment. These are public comments for general business or non-agenda related items. You'll have 3 minutes to speak. When you have 30 seconds left, recording secretary will hold up a yellow card. When your 3 minutes are up, she will hold up a red card. We ask you to please be civil. And we have a sign-up sheet. If you haven't signed up and you still wish to speak, we'll get to you after we finish the sign-up sheet. First up is Cal Murray. For you. That's right.
Commissioners, Cal Murray, 2318 on West Main Street. I'm going to put my glasses on. I'm going to speak tonight on behalf of the Littleton Business Chamber, I am a board member of the board. The Littleton Chamber was recently informed that your planning board is discussing Columbine Square at this evening's meeting. The Chamber's position on this matter is simply that the city of Littleton is challenged to meet its budget and obligation in today's environment due to a lack of sales tax revenue to keep up with today's cost. The Chamber has been informed that the city is considering the following tax increases between 2018 and 2020. 1, fire merger, which shall be a tax increase through mill levy adjustment of approximately 4.6 mills for all businesses and residential property, tax beginning 2019-2020. Number 2, hotel lodging tax increase to be determined. Number 3, sales tax increase to be determined. And number 4, events and seat tax increase to be determined. The Chamber, the Littleton Business Chamber, may or may not be in favor of these future increases considerations. However, we are clearly opposed to the consideration of rezoning and or repurposing Columbine Square from commercial to residential. This piece of ground sits next to the city's largest sales tax collector, Home Depot, and across the street from one of the most successful King Soopers in the state of Colorado. This piece of ground is the Chamber's view. In the Chamber's view, suggests a commercial mixed-use project with many retail destination operation. Thank you, Chamber.
Thank you.
Pat Dunahee. By the way, would you please leave or give us your address and full name?
I will. It's Pat Donahue, 1600 West Mineral Avenue, Littleton. I'm here tonight on behalf of the South Park Business Owners Association. First, I want to thank you for your volunteerism. That's what I am on the board of South Park. We have 322 acres on the south side of town, if you all don't know who we are. Our borders are Broadway and Mineral, County Line, and Broadway down to Santa Fe and Broadway over to, Santa Fe and County Line over to Mineral in Santa Fe. So that big square there is known as South Park, minus the residential component, which is separate from us, which is 176 acres. So back in 1983, we formed a business owners association there in our 322 acres. And in that time, we have come to the city never once for a rezone. It's a business park. We believe in business. We believe in sales tax collection. We believe in growth. We believe in, city improvement and active, positive community. So I would suggest that you possibly think of challenging the developers to try to keep as much commercial on that ground as you can. And all along this corridor would be South Park's opinion to you all. It can be done. It's challenging at times, but we've seemed to do a pretty good job. I think our sales tax revenues for the city of Littleton kind of speak for themselves. We got a lot of nice businesses there that we're very proud of, and I don't think we come up much in your crosshairs here. I don't think you hear much about us. I don't think we're much of a problem, and we have some really good businesses. We collected about, last year, just for reference, we collected about $750,000 for the city in use tax for you all. So I think that in itself just kind of speaks for itself that if you just stay the course, 35 years we've stayed that course and never done a rezone, that if you put the right people in place, I think you can get the right, desired project. I don't know where you're going with this project and what it exists of, and we see a lot of really successful, developments that do have mixed use with some residential in it. We don't argue that those projects are successful out there, but this is 16 acres is what this is all. So I think you could divide up the ground, sell 16 lots to a lot of very interested parties. If the developer doesn't want to take any risks, I'd be glad to, work towards helping that person if you'd like. You all know where I'm at. You all know how to get a hold of me, so whatever I could do in the future. Thanks.
Thank you. We have deja vu all over again. Cal, you wish to speak as a citizen.
Thank you. Good evening. Thank you for volunteering on the chamber. I came to Littleton in 1981 and started a small business. Since then, my business prospered, and I started purchasing properties. Right now, on Main Street, I have 7 total hospitality businesses that I have changed over from what I would consider in those days was a hobby business, when somebody comes in, rents space for $500, $600, or $1,000, and in no time they open it 2 hours a day whenever they feel like it. And my intention was, when I purchased this property, was to turn them over into a hospitality business, which created a lot of traffic in downtown Littleton. The result of that has been tremendous, as you could see when you walk down Main Street. You could see a lot of pedestrians walking up and down Main Street supporting the local businesses. And a matter of fact, 2 of the properties that I purchased, they were residentials. I turned them over to commercial, not just for the fact that they weren't good tenants, but with the commercial application, the tax revenue for the city is much, much greater, plus the commercial property tax. It goes from like about 4 or 5 times the value. I really, in the last couple of years, we've been involved in issues where the city has been changing over commercial property into residential. We all know that the city is in desperate need of funds to keep it moving forward. And if we keep moving on this path, we are going to suffer a lot down the road by tax revenue. So I would encourage you to really consider that as aspect of the change of zoning and keep that as commercial as it is, because the tax revenue will be greater for us than it is a residential. Thank you.
Thank you. Next up is Lisa Sacre.
Thank you. My name is Lisa Sacre. I live by Columbine Square, District 1, and so I travel that area multiple times a day. So I want to thank you for the opportunity to come forward this evening to ask you some simple questions that have come to my mind as I have participated in community inputs and sat and listened to the various presentations. You have identified and briefly described 5 principles, their issues and short and long-term goals for the Bellevue corridor. Citizens' input was very clear on what they wanted and what they didn't want, even though it was a mixed bag. It was also clear from listening to Council's recent study session what they thought should happen. So with everyone's input, it is not enough to have verbal or written descriptions of each of these principles, issues, and goals, but let's take our time and get this right. There are so many unknowns here, especially dealing with Columbine Square folks. I'm asking city staff and consultants to bring forth diagrams of what each short and long-term plan looks like so citizens, councils, city staff, and consultants can all be on the same page. Once we have visuals, we can move forward with some meaningful dialogue as to what the community really wants and can accept, because it is our community that will have to endure the change the city makes every day as they navigate to and from their home, not just the casual visitor. I am also interested in seeing diagrams on how the city is going to use bike lanes, which I disagree with, because of the high volume of traffic there. Maybe it won't be so bad as I envision it to be, but I won't know until I see it on paper, rather than waiting for it to be implemented. Again, so many unknowns. Are you willing to take risks of misjudging what the developers of Columbine Square are going to do or not do? Will they go along with what their neighbors would like to see happen there, or will they be greedy and unresponsive and do what is best for them, as their actions have shown for the last several years? It is also about the money. Unfortunately, the citizens and the city would lose out if their messaging is not loud and clear that the community wants commercial businesses and the integration of O'Toole's and not a mixture of housing. We need to keep that area commercial so economic growth can be vital to this community. I can't spend money at apartment complexes, but I will at restaurants and stores. Heck, I'll even walk to them. An architecture would never build a building without blueprints and pictures, and would never do so without the approval of their clients. The Bellevue Corridor residents are your clients, and we expect the very best from our city leaders. We need to be able to trust you and to know that you have our best interests at hand, not the developers and not the consultants. You will also get a one shot at doing this right. It's worth taking the time and not wasting money, for it is not a do or die project. So I'm asking you and council to postpone this vote until those affected by this project all agree on the plans, which needs to include the Columbine Square developer. Since they play a huge role in this project, pressure needs to be put on them to start coming to the table with solutions. There will not be...
Your time is up.
Okay, thank you.
You can give you 30 seconds or 10 seconds to finish up if you want.
I just had one more sentence.
Go ahead, quickly.
Okay, there will need to be more community meetings where citizens can view and vote for the changes, but in the end, it will all be well worth it, and the wait and patience of all invested in this project. Thank you for your time.
Carol Brechak.
I'm Carol Brezak. I live in the 4th District. We've started an endeavor with Kindig and Keys to approach these situations very differently than the way this one was approached. This is a process that we've used, and it has not been productive in the past, where we have someone from outside the city come in, put a plan together, then you get the citizens together and ask them to comment on it. You would have ended up with a completely different document if you had started out with citizens to begin with and let them put the plan together. But that's not what you have. I think there's a push for this. The mayor said it at a meeting the other night. Columbine Square people are waiting for this to be passed in order to move on with their project. To some of the nuts and bolts of this, in here you talk about the neighborhood compatibility and trying to match the character, the density, and the scale of the adjacent homes, respecting the established setbacks, etc. But if you don't define what that means, then you can't protect it. And there's nowhere in this document that defines what the existing character is, which is exactly what Kindig and Keys can do. And then you go over to the Columbine Square area, and it talks about the kind of housing that will be perhaps developed there, and it is not consistent with the existing character of that neighborhood. I think about the Grove and how we got where we are with that, and it's really hard for me to feel that this document's going to protect that neighborhood over there, knowing what can happen and what did happen in Littleton. And so I'd like to see more definition and more protection in this document for the neighborhood over there. I'd like to see somebody address the economic sustainability, because it's an important factor. It costs the city for residential. Commercial, it's a different story. So how much commercial land are we going to give up in order to put more burden on the city's general fund? I think it's a conversation that is really worth having. There's not a timeline in here, and of course a lot of this is pie in the sky because there's a lot of money that's attached to it. So it would be nice if it was kind of laid out in what you can actually do and what you can't do. There's some of the things in here that involve the city of Inglewood, and in talking to a city council member at Inglewood, they're not connected to any of this. They haven't. It's not on her radar screen, so I'm not sure how much of this is even doable when it comes to the city of Inglewood. So I think this isn't quite ready for prime time. I think there needs to be some more protections built into it for the community over there. Thank you.
Thank you. Don? Pronounce your last name again, I always forget.
Bruns.
Bruns?
Yep.
Try to remember next time. Ah.
There it is.
Okay. Can you read that?
Don Bruns, District 4, 7332 South Costilla. Commissioner Rednicki and other commissioners, greetings. It's been observed that all of us struggle to understand things we're unprepared or actually unable to hear. The subject draft before Commission this evening for Bellevue Corridor illustrates that principle. Its content reveals that the city and its trusted contractor have been able to hear only some public concerns being expressed by affected publics. This body is named the Planning Commission, yet this work is staffed by our Municipal Community Development Department, and some commissioners are actually developers themselves. Probably then, none of us should be surprised if the draft plan and the accompanying dialogue of staff consultants and even some commission members often appears to resemble that of a development commission instead. So what's needed is a community resource stewardship emphasis that would balance the draft's redevelopment focus. Now, I submitted 3 pages of comments to you, and I can't get through all of that in 3 minutes. And I'll just say, to illustrate, I cited 8 examples. And let me just say that those observations are of what I saw as content that's alarming or alarming statements, but they're not, my observations are not intended to be disparaging of anyone. Now I want to move to the overhead. There are at least 4 different levels of planning, and I'm not suggesting that this plan has to accomplish or encompass all of those, but it's clear that citizen concerns do span all of those. Now, in my planning career, and I worked in land use planning and recreation and scenery management, and I was trained in project level, planning levels 1 and 2, and a lot of my colleagues couldn't get beyond that. And I think that that's one of the things I see the commission and the work of the consultants struggle with. And I see sometimes that you appear to be conflicted. You're right on the edge of walking into that new room of the universe, but it's difficult to step into it. I had colleagues who would not step in. Some said, I don't want to, and others said, I'm not going to do it. But the things that you've heard others express here and that were expressed publicly in this process deal with land use character and planning and that deal with community and resource character. And the other thing that citizens really want to know, if we give them the opportunity to say, if we give them a survey and we don't actually spell this stuff out, they're harder to understand at the top level, but they matter greatly because all of us are concerned about our quality of life and what this plan will do to affected citizen publics. And so that's the remainder of my comments actually deal with that. I just want to say, to summarize, noticeably missing is objective definition of planned desired future community character conditions and the identification of the end results that citizens desire. And because we're doing this, a revised comprehensive plan vision to comp plan to zoning, it's absolutely crucial that this be addressed before this thing goes forward. Otherwise, it'll be very difficult to interface this with what citizens really want and where this whole process is going for really a responsive plan. Thank you very much for the opportunity to comment.
Thank you. Not sure of the first name, Erickson? Jeannie? Okay.
Good evening, Planning Commission. My name is Jeannie Erickson. I live in District 1, really near this Columbine Square and Bellevue Corridor. I attended all 3 of the meetings held by the city. In speaking to my fellow neighbors, I discovered that most of them were there because of their concerns regarding the formerly known property, Columbine Square, and they were very concerned about what may be built there on the corner of Federal and Bellevue. They were quite concerned that the landowner is going to try to put up high-rise density apartments on the site, which none of them wanted at that intersection. We definitely have a fair share of apartments in this area and think apartments are not the correct fit for this site. I also spoke with people that wanted to keep it retail, make it a park, and those who thought some type of industry office building would be a good fit. The comparison in your packet is comparing that site to a 27-acre parcel in Denver. I don't think that's a good comparison. It also says in your packet that this site is 7 acres. I am told that this site is 15 acres. The owner of the property has not been a good neighbor to Littleton and does not need any help from urban renewal. I would hate to see the paragraph that you have in your packet regarding urban renewal do exactly that. Give this landowner urban renewal money. This landowner is a multi-billionaire and owns many, many properties across the country. Urban renewal is made to make it work for someone who does not have the money. It is not made for people like this. He also blighted his own property by kicking out all of his tenants nearly 5 years ago by not renewing the leases and letting them move out little by little, making it look like they were just moving out when they actually got booted out. For what reason, I don't know. Please do not vote for this plan, because if voting for this gives the landowner any urban renewal money, it would be a disgrace to the citizens of Littleton. If urban renewal money is given at this site, citizens would not see any sales tax revenue from this site for over 20 years. At the City Council study session last Tuesday, the finance director stated Littleton is below what they predicted in sales tax revenue for 2017. This is one of the largest chunks of land we have left in Littleton that is currently vacant and is zoned retail. Once we give up land to housing, we are not going to get it back. Littleton needs retail to keep the city running. Thank you.
Thank you. Pam Chadbourne.
I'm Pam Chadbourne. I live a block and a half from here, and I'm going to ask you to table this to a later date, a date certain. Give yourself enough times to do at a minimum. If you feel like you got to get something else out, change the name. It's not a plan. But you should take time to fix the weaknesses. And by the way, the citizen comments up to now, I really can't express my admiration for the citizens and the quality of the citizens we have here in Littleton. I am eternally grateful to the people who have spoken, and I ask you to listen to what they have said. So I want you to table this to a date certain to do 5 things. Change the name from plan to something like concept or study. This is not a plan. Remove the addition of the housing use from the Columbine Square site, or make continued community business use much stronger. And note the date. The day that I agree with Cal and Pat is a red letter day. This is a great day. Let's celebrate it. We agree on this. It is amazing, and you should be compelled by that alone. The economic basis for this document is a major weakness. This is one little study by the consultant. We, the city, did our own economic analysis, and at a minimum, they should be reconciled and incorporated. Relying on one limited, tiny study as a basis for this plan is a fundamental weakness. It is a flaw, and this plan cannot proceed with that basis. There is no or inadequate protection for the South Platte River in this document. That's fatal right there too. And there is no provision for designing redevelopment based on traffic performance requirements. I'm sorry that this is a late request. However, and look, Lisa said this, get it right. Take the time to do it right. I'm sorry about that, but this is where we should spend the money. Something really disappointing happened in this process. There was only one presentation by the city with an interactive public discussion, and that was a cold night. The next meeting was very well attended, and you could just feel the crowd deflate. We walked in, and there were tripods around. There was no presentation. There was no public discussion. It was very disappointing, and you could just feel citizens pull back. I have no idea how the housing use at Columbine Square got into this after the citizens were so clear after that. A problem here is we're focusing on a document, a noun, rather than a document plan, which documents the plan that we've developed. And a couple of speakers already referred to that. Now, the rest of my view graphs relate to the 5 points that I described, and they were in email that I sent, which I hope you received. Please listen to us tonight. Table this to a later date. Change the name and fix the weaknesses. Thank you very much.
Thank you. Is there anyone that didn't sign up that wishes to speak? Seeing none, we'll move on. Next item is our general business item, PC Resolution 14, 2018, resolution recommending City Council action on the Bellevue Avenue Corridor Plan. We'll start out by, just want to make a comment about the public input. I've been around long enough to be involved with other plans, corridor plans, where the public was hardly ever consulted at all. Specifically, I'm thinking of the Santa Fe corridor study. What I've seen in the last few years is the chance for public input has increased dramatically. The Bellevue corridor plan had 3 public hearings. Also, people could make their comments online. We got a lot of comment this time around from the public. With that said, the Planning Commission did not get the over 100 pages of public comment that were made during the 3 public forums or the comments online. It is my suggestion that the Planning Commission table the discussion tonight on the Bellevue Corridor Plan until our next meeting, so we all have a chance to read through the 100 pages, find out exactly firsthand what the public has talked about. We do have some members of the Planning Commission that did show up for some of the public forum meetings. Others did not. We also have some new members on the Planning Commission that did not go to any of the meetings. So I'll open up for discussion and the possibility of tabling the discussion and vote tonight.
Chair Rudnicki, may I just ask or offer a clarification? It
Yes.
was an oversight on staff's part. It was not intentional
Right.
for you not to have that. I just want to clarify that. It was just a mistake, but we would like to make sure you have time to
No,
look at
and
this.
I wasn't
Just
meant to,
want-
I don't think you deceived us. We had a situation for the mineral station, light rail station, where we had over 160 pages of public comment attached, and we were able to look through it quite a few times. That was very helpful in forming our opinion and helped with our vote on the mineral station master, or what we call it, the framework. So, comment, discussion? We will have a vote either to table or continue as planned.
I've got a question.
Yes.
Yes. Okay. I guess a question with respect to the process. Say hypothetically, we look through all of the commentary, the public citizen input, and want to then make modifications of substantive modifications at some level to what's in here. So I'm sitting here looking at the Columbine Square piece, and what if we decided to do that? The next meeting is what, the 25th? I guess, Jocelyn, what do you envision then as an opportunity to assimilate, as far as the board's concerned, our ability to digest what's in there in these 100 and some odd pages relative to what we're seeing here, and then effectuate changes as appropriate?
I guess you have several options, and I'll speak, and then Steve can follow up if need be. Your option, so the idea would be that you would be tabling this agenda item until potentially the 25th of June, which is the next regularly scheduled Planning Commission meeting. I mean, within that, you have several options, as you do this evening. Would be, you would have time to then review the public comment to make sure you feel that the plan adequately addresses what you feel is the public comment. If you don't, then you obviously can bring either of those general comments to insert into the document, or if the level is so substantial that you want to see wholesale changes, I mean, the other option would be to give staff the direction to say, hey, we feel the public comment wasn't addressed as well in this plan, so we're sending it back to you to fix it and bring it back to us, maybe even a study session or something like that, to evaluate whatever our potential concerns might be.
Okay, and
But
how does-
It's all of those options.
That's fine. Go ahead, Steve.
Mr. Stillman, members of the commission, yes, I would agree with Jocelyn's options. I mean, obviously, you would have the option, work through the public comments tonight, recommend it as is, work through the public comments tonight, and then decide it needs amendments, recommend it to the council with amendments. If you thought it was so unsatisfactory, you could actually recommend to council either be rejected or recommend and ask staff not to proceed further with it until changes are made and bring it back.
Okay.
Now, you do have a motion to table, which this is a precedential motion, as we're going to talk about in the study session, so you really need to resolve this motion before you get into substantive discussion.
Well,
There is no motion.
we
yet.
haven't made a motion yet.
Okay, then.
Yeah, okay. And then, I guess the only other question, and it's not, it doesn't affect what we need to do with this document, but I want to be sensitive to council's agenda in terms of getting this thing turned around as it moves later into the summer kind of thing. I mean, this is something that would still be able to be taken up by council this year, right? We don't want to defer these things interminably.
Yeah, yes, that is correct. And actually, when staff looked at the potential of tabling this till your next meeting, that actually does not change the process moving forward to get it to council, because we were already in a further in July tentative schedule anyway, so it wouldn't impact that at the moment.
Thank you.
Comments? Go ahead.
Yeah, another question. One about the role of the Carter Plan with respect to a particular site. We heard some really good comments, I think, from some very informed and articulate citizens. I'm new to the process, so I didn't have the opportunity to participate in the public process or review extensively the public comments. So I'd like to have some time to go back and do that. But the Carter Plan, as I understand it, is a larger overlay, if you will, not focused particularly on the Columbine Square development, but to the extent that it may enable or entitle the developer there, I would certainly have some concerns. I did hear most of the comments focused on Columbine Square. There was some about the river crossing as well, which would be a concern. But I guess my concern is the role of this document in terms of establishing a city's vision, the citizens' vision for this corridor should be proactive in terms of establishing some control or guidance for any types of development that happen along there, not just Columbine Square. So am I missing something in terms of how this is applied?
You want to take that? You want me to take it? Sure. Members of the commission, this is commonly what might be referred to in some jurisdictions as a specific area plan or corridor plan. The idea, it's not, and in different jurisdictions, sometimes your specific plans can actually be what we call a regulatory plan, which actually creates a whole new layer of regulations on top of the general plan. This is not designed to be a regulatory plan. It's designed to be more of a set of specific guidelines that the city could look at in terms of the future for various development plans. For example, outside of the zoning context, but related to it, would be whether there should be improvements made to Bellevue Avenue. It's a state highway, but it's also within the city, and the city would have the ability to negotiate with the state over such improvements. That would be something that might flow out of this plan. What might flow out of this plan as well would be whether there were any other transportation corridors that, by making improvements to, might facilitate the goals of this plan. You would also look at other things such as could there be some degree of working with property owners on better accesses, control of accesses, installation of medians at intersections, those types of things? All of those flow out of this sort of document of guidelines, but this isn't what you might see in some cities as a regulatory type plan. It's more a set of guidelines that will allow the city for the future to take those into account as it sees particular development applications or particular city projects.
I would just add to that that if you recall, City Council directed us all to take this project on, and I think it was after a study session with Planning Commission. Now, it may have been a previous Planning Commission, not everyone seated here this evening, because we don't have any visionary comprehensive plan, corridor plans for this area of the city. So there was some concern about wanting to have that put in place so that as we see changes happening along Bellevue Corridor with the private properties and land use along that corridor, that at least we had some guiding documents that gave us some direction. But absolutely, if Columbine Square is interested in doing something on that property, they can bring that forward under their existing zoning, or they would still have to go through any and all appropriate land use processes to make a change to what they wanted to construct out there.
Okay, thank you. And so if I may follow up.
Sure.
It's the way I read that component, I think it's under Chapter 4, Opportunity Area 1. It was our consultants and our staffs and our commission's sort of interpretation of what was heard at the public meeting in terms of a vision, or community meetings in terms of a vision for what that site might be or is headed toward. It's not necessarily prescribing what that site should be.
That's correct, because there was a variety of opinions and input regarding all of the opportunity areas, and the focus was on the commercial zone properties along Bellevue that were identified as future opportunity areas.
Anyone else on this side? Any comments?
Just to the thoughts of being able to review the 100-odd pages of community input, what I'd really like to see is, if we do table this to the next available meeting, is sort of how did those develop into the plan that we have before us, and how did the community input get factored in, and how was that incorporated into the plan in addition to the economic analysis? So if we do move in that direction, that's something that I'd like to hear about during the staff presentation.
Okay, in 2 weeks or now?
In 2 weeks.
Okay. This side?
What I would like to see, based on listening to the conversation tonight from the community, they have some very specific concerns. I personally have some very specific concerns with this. I'd like to see it go back to a study session where we as a group can hash out the things that we're learning and hearing tonight, along with after having the opportunity of reading the 100+ pages, and take a look to see if there's some other things that need to be worked out here. I will say, from what I have seen so far, I am not comfortable with this plan going forward. So I see it beneficial to go back to another study session and really talk about the concerns we've heard tonight also.
Anyone else? Seeing none, we have no motion. Do we have a motion?
Move to continue Planning Commission Resolution 14-2018 to 25 June 2018.
Second.
We have a second? Okay. Any discussion?
I'd like to learn if there is any others who have the same desire I do as going to a study session. If not, I wouldn't move to do anything different. But does anybody else have the same concerns I do and like to see this in another study session before we go to bring this to vote on as a resolution?
Well, my position has evolved in the last few minutes. I like the idea of a study session. We have a motion, so we will vote on it, but I think the study session has merit. Step back a little bit, take another look, have an opportunity to change the plan in a little more, less in the fire type situation that we would in a public hearing. So.
So, Steve, is there any way that with the motion on the table, I can make any kind of amendment where we can do a study session first and still get the, this motion, or no?
Members of the commission, no, this is a precedential motion, so it's not subject to amendment. If you vote this motion to continue down, you could certainly entertain another motion that would continue it and direct staff to schedule a study session. But because this is what is called a precedential motion, it's only open to discussion on this. You have to vote on it, and then based on what happens to it, the chair could entertain another motion.
Can we vote on this and say it passes? Can we then also vote on the study session right after that and maybe then change this?
If this is carried over, my recommendation would be that simply at the next meeting, if the commission feels it needs a study session, it simply would not entertain the item, but just direct that staff schedule a study session.
Thank you, Steve.
You want to make a comment? No. Okay. We have a motion and a second. Please vote. Here we go again. Sorry.
You have to do
no
it by
clicking.
voice today, old-fashioned.
All right, the motion on the table is to continue until June 25. Okay, Commissioner Coronado?
Aye.
Commissioner Reynolds?
Yes.
Commissioner Stallman?
Aye.
Commissioner Rudnicki?
No.
Commissioner Bolt?
Yes.
Commissioner Schwartzbacher?
No.
And Commissioner Breidenbach?
No.
Okay, so that's 3 against. The motion, wait,
Four in favor, 3
Four in
against.
favor.
yeah,
Motion passes.
motion passes.
Okay. So this discussion, the general business will be continued on the 25th. That is all on our agenda. Are there any staff reports, comments? Okay. Any commissioner comments? Seeing none, we're now going to adjourn and go to the community room for legal discussion. Meeting is adjourned.
Everything's noted?
I got it.
We also have the Colorado Open Meetings Law. And that is part of, it's commonly called in Colorado, the Colorado Sunshine Law. But it basically means you can only vote on things on your agenda. You can only discuss things on your agenda. You can't discuss things that are not on your agenda. All of your sessions must be open. You cannot have, as a city board or commission, you cannot have executive sessions except for two very limited reasons. One is a record that is confidential by federal or state law. The other is if you are a party to actual litigation in a Colorado court. Short of that, there will be no closed sessions. Now, the city charter also has some references to zoning, and the important thing to know is planning is a legislatively created function. It's not a function that is inherent to local government. It is a creature of the legislature and state law. Now, the city has adopted legislative rules, and those also are binding upon the planning board. One of the things in those legislative rules is that if something's not addressed, Robert's Rules of Order may be used as a reference. So we will talk a little bit later about that. Now, this board acts in three different ways: legislative, quasi-judicial, and what we call adjudicatory. Now, in the legislative capacity, and a good example is tonight in considering this resolution on the Bellevue Corridor, you're acting as a legislative body. That means that you get to consider all information from any source in making a decision. You are able to make a decision based on even evidence not contained in the record, and you are only required to have what we call fairness in the procedure. And the legislative act. The legislature is not a judicial body, it's a legislative body. Now, much of the time in Colorado, you act in a quasi-judicial fashion, such as zoning, such as if you were to do a regulatory specific area plan as compared to just a set of guidelines. Now, when you're acting in a quasi-judicial capacity, you are acting just like a judge. And you have to base your decision only on what is in the official record, the codes, statutes, and court decisions. You cannot consider information outside the record. Citizen comments can be considered because they are part of the record. And in fact, you will be receiving shortly, courtesy of the City Council, the City Council's adopted rules of quasi-judicial procedure across the entire city. And they are in the process of being published, and every commission that has quasi-judicial functions will receive those. Now, unlike some states, as I mentioned, zoning in this state is a quasi-judicial function. Before I came to Colorado, I practiced law in Arizona. Arizona, zoning was a legislative function, not quasi-judicial. But here's quasi-judicial. Now, one of the most important things about quasi-judicial just was discussed in the last week or so. Most of you, if not everybody here, is familiar with a case called Masterpiece Cake Shop out of the city of Lakewood versus the Colorado Civil Rights Commission. This case goes up to the Supreme Court. Now, the case itself involved a baker who did not want to make a custom cake for two men who were being married because it violated his religious beliefs against same-sex marriage. He would sell any other cake in the store, he would do anything, but he did not want to do the custom cake. When the case came to the Colorado Civil Rights Commission, a quasi-judicial body acting in what we call an adjudicatory capacity, a couple of commissioners had to give their own opinions about religion. And of all the things, those opinions were the basis for the United States Supreme Court decision finding that the commission was so hostile to religion that there was not a fair hearing of the baker's religious claims underlying what he was doing. Why is that case important to all of you? Because your comments in a quasi-judicial proceeding, just like a judge's comments from the bench, can be used to demonstrate that the proceeding was not fair and did not meet the minimum rules for a judicial proceeding and therefore should be overturned. Yes?
Can comments like those outside of the official proceeding also be considered?
Comments outside, you cannot consider things outside the record.
I mean, the comments that those guys made, they made them outside the proceeding.
If you were a board member making them outside, yes, I would tell you that if there is a record of those, that can be used to question your impartiality. When we have a quasi-judicial proceeding, you're functioning just like a judge. You have to be impartial. What that means is that you don't talk with people about it, you don't express your opinions. I've served as an arbitrator or a judge in my career, and when I hear evidence, obviously I have my own expertise, my own background, my own knowledge, but I can't be prejudiced even from outside comments. And it's very important because just like what happened with the Civil Rights Commission, I read an estimate that that case from the time it started here in Colorado all the way through the U.S. Supreme Court ran the two sides in excess of $2 million in legal fees. And it ends up with a couple of comments. So it's just very, very important. As I mentioned, not everything is quasi-judicial in front of the Planning Commission. Now, there are these things which we call adjudicatory. What that means is you're acting as a regulatory body reviewing staff actions. And the classic examples of those are site plans, zoning administrator interpretations, or preliminary plans. Now, there are some basic rules in this adjudicatory area that's just important to understand. The first one is that the board is required to give deference to the judgment of staff. That means that if all things are equal, you defer to the judgment of the administrative agency. And the standard for overturning the judgment of the administrative agency is what we call arbitrary, unreasonable, and capricious, which are three very fancy legal words, but we can put them down to plain English. Arbitrary simply means that the staff didn't follow the rules. It just did whatever it wanted. Unreasonable means that a reasonable person could not have found any justification for what the decision was. And capricious means it was simply decided without regard to any facts in the code. Now, we do have a few federal laws that are important to keep in mind because they do impact what you do. First is the Americans with Disabilities Act. It requires public entities to have a plan to provide disabled persons with access to all public meetings and facilities, and we must provide reasonable accommodation to people with disabilities. For example, if we had a person who contacted us who was visually impaired who wanted to attend tonight's meeting, we would make arrangements for them to either see the meeting using TDY or some other technology where they would be able to access the proceedings. A second federal law is the Federal Fair Housing Act. And The Federal Fair Housing Act provides that cities cannot engage in discriminatory practices that would deny housing opportunities to individuals based on race, sex, national origin, disability, familial status, and age. In a city I was in, not this city, a multifamily housing project came into the commission. And the neighborhoods did not want it. They said, we do not want apartments. So the testimony in front of the commission was, well, you know, people in apartments use drugs, they're all criminals, they have loose morals, they are simply not the kind of people who should be in our neighborhood. I had to caution both the commission and the commission chair, you're not to consider any of those comments. Those comments would be regarded by the courts if they were considered in any way, shape, or form as actions by a city engaging in a discriminatory practice. And familial status means we treat everybody in the household the same, regardless of whether they're related by blood or marriage. It may be that I really like having, I hang out with planners all the time. Well, the fact that they're not part of my family, but there's 4 people in the household living together, you can't say, well, the household that has 4 people over here by virtue of blood or marriage is a family, but this one over here, because they're foreign related people, can't be a family. That will also constitute a violation of the Federal Fair Housing Act.
I remember a situation in my neighborhood where there were 12 people living in the house, most of them unrelated, and Littleton bore down on them.
Now,
is that law now off the books in the last few years?
Well, we can address other things. For example, if the house doesn't have enough space, we can address it through the fire code, because that isn't based on familial status. Okay. That's simply based on the fact that there has to be a minimum number of space per person. It's just like if the house doesn't have a functioning restroom, the fact that whether you have familial status or not, we can deal with the house because it's a fire code, it's a residential property maintenance code issue. But in the zoning context, we have to simply look and make sure we're not looking at these prohibited factors. Now, one of the big issues that comes up, particularly under both the Americans with Disabilities Act and the Federal Fair Housing Act amendments, are group homes. I have not been in a jurisdiction in my whole career where I haven't had a group home issue. First, again, some cities have said, well, we don't want these except maybe in commercial areas. You cannot do that. They have to be treated in the same way that you would treat other residential facilities from a land use standpoint. Now, we can regulate lots of other things from a fire code standpoint, from a property maintenance standpoint, but we have to be careful in how we regulate those from a land use standpoint. The other is a federal law, the Religious Land Use and Institutionalized Persons Act. The short name is RLUIPA. What does this law mean? It says that a state or local government cannot excessively burden religious expression in the land use and institutionalized persons area without having what we call a compelling state interest. We have a large city in Arizona, a very, very large city, well known. There's a baseball team called the Diamondbacks that plays there. And that city decided, oh, well, we don't really think people should be having Bible studies in their house. And they actually enacted a zoning regulation to address that. And they were sued under RLUIPA, and it was struck down because the court said, listen, there's other far less intrusive ways you can deal with this. You can set time restrictions, you can set parking restrictions. You can't tell people they can't practice their religious faith in their house. Occasionally this will come up in the church context. There was another well-known church in a city adjacent to where I practiced, where the neighbors, this church is characterized by having steeples on their churches as compared to any other kind of religious symbols. The neighbors did not like a steeple. And they went to the city and asked the city to impose, as part of the conditional use permit, a no steeple requirement. No, that's not going to work. That is guaranteed to get a lawsuit under the LUPA.
Well, what about a situation where a prayer group is 30 people in a house every night of the week, not just occasional bring in 4 buddies? And what happens then?
I think there's a point where we can say, listen, you're acting like, it's what I like to call the duck rule. If it looks like a duck, quacks like a duck, it's a duck. Okay. If you look like a church, you act like a church, and you behave like a church, you're a church. It doesn't matter that you're meeting in a house, you're a church. And sometimes people will say, well, why don't you just permit churches in our zones? This very reason. If we make churches principal permitted uses in all zones and have no restrictions, you can easily get into a problem where you can have incompatible uses.
Property tax either.
Yes. Now, one of the other things that gets very common in this area is use of zoning to try to restrict churches in functions such as supporting the homeless or feeding kitchens or water stations. Again, there was a city in Arizona. It happened to be about 120 miles down the road from Phoenix, and well as where the U of A is, called Tucson, and they decided that they wanted to restrict feeding kitchens and water stations. Churches weren't to have those. And again, clear, you can't do that. You cannot, the courts have said, listen, those are part and parcel of a church's religious beliefs. You can certainly put restrictions on them and say, you can't have a feeding kitchen at 12 a.m. in the morning, but you can't simply say, you shall not have a feeding kitchen for the homeless at all. And so the important thing here is that if we get into things that look like we're getting into a LUPA issue, you would definitely know, we would definitely be talking about that. Now, that covers planning and zoning, but we have 2 other very quick presentations, and let me see if I can get back to the This is what happens when you get a lawyer deal with technology.
Or a lawyer dealing with lawyer issues? Okay.
Is Denise still here? Or no? She's not. Well, she said she put it on a thumb drive. Oh, USB drive. Let's try D. Oh, yes, right there. Let's talk about regulatory takings. The next issue we're going to talk about very quickly is this idea of taking. Now, this has been an area that has frustrated the U.S. Supreme Court for the last 100 years. And they have had difficulty with it. So, there are some, just what I view as very, very important principles to know. And again, the key is that you know the important principles. When these situations come up, then they become a bit easier to address. So first, what is the takings clause? Takings comes out of both federal and state constitutional law. Federal constitutional law comes out of the Fifth Amendment. No person may be deprived of property without due process of law. There's a very similar provision in the Colorado Constitution. Those form the basis for takings. Now note it says without just compensation. Now, the idea of this is that government shouldn't be able to take one person's property and make them bear all of the costs that should be borne by the public as a whole. And there's been really 5 major cases the U.S. Supreme Court has had on takings. And you can look at those 5 cases, and those cases really tell us what we need to know about takings. The first is a case called First Evangelical Lutheran. A Lutheran church in California had a church camp. California had a flood. Camp was destroyed. The Lutheran church said, oh, we want to rebuild. California says, no. Lutheran church sues, saying, wait a second, you're taking our property. We had a use. You're now saying we can't rebuild. You're effectively condemning our property just as if the government was seeking to take it for a public purpose. And the U.S. Supreme Court agreed with the church. Now, what we mean by condemnation, you'll hear another term used for it. The fancy legal term is eminent domain. But what it basically means is the government is finding that there's a public purpose that requires it take individuals' property, whether they agree to sell or not, for just compensation. Now, we will get to a couple of cases that talk about indirect condemnation. Indirect condemnation is where the government does something that effectively takes your property without actually taking it. So after First Evangelical, a year or 2 passed, and there was a second case out of California called Nolan versus California Coastal Commission. Mr. Nolan happened to be a city attorney for Los Angeles, of all things. The California Coastal Commission regulates construction and development along the Pacific Ocean. It said to Mr. Nolan, you want a building permit to expand your house? You need to dedicate us an easement down to the ocean so the public can access the ocean. Mr. Nolan said, oh, of course I will. Pay me for it. Oh, well, we don't want to pay you for it. You need to do it for free. Now, his house wasn't taken. He still had his house. But a portion of his, and he still had a portion, all the property. It wasn't taken. It was just an easement. The U.S. Supreme Court said, no, you cannot force a person to dedicate an easement unless you can show a direct relationship between what they're doing and the need for the easement. So we go a little bit longer.
And compensation as well.
And California had to pay him compensation if they wanted the easement. And so we get to a third case called Lucas. Lucas involves South Carolina and also the coast. It just happened to be the other ocean, the Atlantic versus the Pacific. South Carolina had hurricanes. South Carolina said you can't build on the coast anymore. Mr. Lucas said, oh yes, I can. I had a house here. South Carolina said, no, your house was destroyed. What the court said there was, again, government can impose rules and regulations, but if a person had a reasonable expectation that they could use the property for its intended purpose, that could constitute a taking. Now, as you can see, with the direct condemnations are what we call really traditional things. Reservoirs, highways, infrastructures. Now, in some states, you can have even economic development as a grounds for condemnation. Other states, you can't. Indirect condemnation is what we just talked about, where the government engages in some conduct that triggers a requirement to pay, even though the government has not taken the property. So let's talk about the fourth case, which is a well-known case called Dolan versus City of Tigard in Oregon. Mrs. Dolan had a hardware store, and she wanted to expand her hardware store. And so she goes to the city, and the city says, why, Ms. Dolan, of course you can expand your hardware store. You need to dedicate us this much right-of-way for parking. You need to dedicate us this much right-of-way for retention. And by the way, you need to dedicate to us this much right-of-way for a bicycle path. Ms. Dolan said, My hardware store doesn't need any bicycles. Doesn't sell any bicycles. Bicycles have nothing to do. And that case also went to the U.S. Supreme Court. And the U.S. Supreme Court said, listen, when you do these types of requirements, government, there has to be what we call a reasonable connection or reasonable nexus between the requirements you're imposing and the action that the property owner is seeking. In this case, the testimony was no one had ever come to Mr. Dolan's hardware store by bicycle. That the hardware store created no impacts on the need for a bicycle. And the Supreme Court said that goes too far. So sometimes these takings can be where the government, like in Lucas, actually takes the property. Many times it's where the government imposes a regulation that makes it impossible for the property owner to use their property. Now, the last case was a case out of Florida, and it involved a property owner who was required to dedicate wetlands as part of the development. And he said, wait a second, Supreme Court, this is outrageous. These people are making me dedicate like 90% of my property is wetlands and I only get to develop 10. It's a taking. Interestingly enough, the Supreme Court said there, no, your property is taking away wetlands, and wetlands are critical in South Florida to avoid flooding, to avoid damage from hurricanes, and to minimize some of the other issues with loss of habitat. We're not going to, you're still going to develop your property. The fact that you have to dedicate a huge amount of it as wetlands, your property is just such that it's not an unreasonable requirement. So the key thing here with takings is that one of the justices on the Supreme Court described it as when a city or a government has gone a bit too far. And I understand that doesn't really seem like much of a legal explanation, but it really gets right to the point. When you have a situation where you've required as a condition an exaction that effectively does take a property, then you begin to get a takings issue. We work very, very hard with your staff in terms of reviewing cases and things to avoid takings issues. And because they can become very expensive. Yes?
Totally understand the indirect version.
Yes.
If memory serves, what was it, 3-4 years ago, council passed a resolution prohibiting eminent domain, which presumably is direct taking. So I mean, that's something the city already has. I think it's in the code.
Yes, there was a charter amendment that prohibited eminent domain without a popular vote.
That's what it was.
For urban renewal projects.
Right.
Now, if that was to come up, the fact that the public voted on it doesn't prevent it from being a takings. We still, even if we were to submit something the public would vote on it, we would still do the same type of takings analysis and say, well, it's nice that the public voted on it, but what the public just voted on goes too far and constitutes a takings.
Okay, right.
Now, what the courts have said, however, is the courts have said that, listen, a lot of things that are exactions, if there's what Justice Rehnquist called the traditional type of exaction, some right-of-way for a road or some right-of-way for sidewalk, that those are viewed as just normal things a property owner has to do for development. And the court is very, very flexible and willing to recognize those types of exactions. And so, I mean, I've had property owners, well, I don't want to put in a 5-foot sidewalk. Well, yes, you're going to put a 5-foot sidewalk. The United States Supreme Court has never said that that is a takings. And we talked about Lucas, so I'm going to skip the Lucas slide and the Penn Central slide because we've talked a little bit about those. And on any of these cases, I'm happy to, at some point, spend some time if we have a takings issue, talk about them in more detail. Now, one of the issues that does come up on takings, and this has been a major question recently with the U.S. Supreme Court, is when we look at a takings parcel, we look at the parcel as a whole. We don't say, for example, a property owner says, well, yes, you've imposed a requirement on half my property, so half of it I don't have any use on. I want to be compensated. No, we look at the whole parcel, and we analyze the whole parcel as to whether a takings has occurred. A lot of property owners have tried to make this argument, well, you just need to look at part of my parcel versus all my parcel. And the courts have said, the U.S. Supreme Court has said no. When we look at these cases involving regulations, we look at the parcel as a whole. Now, one other interesting thing about takings, and that will be the conclusion of this discussion, and we'll move on to Robert's Rules. There is a citizens' initiative that's being circulated right now in Colorado for the November ballot. And it proposes to look at takings and saying that there should be a state law right to a recovery for a loss of value resulting from governmental regulations. Now, how that would work is, normally the courts have said, listen, government does lots of things that may cause your property to lose value. Government may change the tax code. Anyone in here who owns a house, if government was suddenly to end a mortgage interest deduction, I hate to tell you what's going to happen to your house values. They're going to drop. Every economist has said that would force a drop in housing values. Now, do you get to sue the federal government for changing the Internal Revenue Code? No, the courts have said that is not a takings. It may be terrible, it may be bad, it may be horrible public policy, but you don't get to sue under the Fifth Amendment for a takings. And so that is where this type of citizens initiative is saying, wait a second, we do want to create a right to where you can sue for government acts that actually impact your property and reduce its value. Whether that's a good idea or not, yes?
Well, if they start the war, then it affects my property value. I can sue the government for starting the war. Oh my God.
Well, that would be the argument. Now, in most states, there's a few states that have this. A good example is Florida, Arizona both have this. What the courts have said is that you're going to have to be able to show somehow that the regulation directly resulted in a loss of your property value, that something of just broad general applicability that relates to public health, safety, and welfare generally is going to be excluded. So things more like, say, for example, because of water shortages, we require that everyone now has to have xeriscape in their front yards. All that grass in your front yards has to go. Some people just don't like black front yards, and that may result in the value of your house. In Florida or Arizona, you would actually be able to sue and argue that that regulation has resulted in a loss of value, and you say you should receive compensation.
Just one other kind of takings that it's always been interesting. Let's say there's a beat store on a valuable corner in a city. City condemns the property, and then they've got a buddy that wants to put in a sexy new high-rise, bringing in lots of money into the city. So it's just choosing sides, who's the winner and loser in a commercial situation. I think it happened in Rhode Island or Massachusetts.
Yes, and it happened in a case in Connecticut called Kingo versus New Haven, Connecticut.
So what's the outcome of that normally? It happens apparently.
But in that case, the U.S. Supreme Court upheld the city of New Haven actually condemning the property and taking the property for resale to a third party. Now, interestingly enough, after all this was done, the third party happened to be Pfizer Pharmaceuticals. They canceled the project and never built it. So the city of New Haven ended up with a huge bunch of property and no project. There was a very similar case on a more sort of narrow scale. City of Mesa, Arizona decided, oh, well, our downtown would really benefit by having an Ace Hardware. So we're going to condemn a long-time auto shop. Been there for 50 years. We're going to tear it down, sell the property to a developer who's going to build Ace Hardware. And they went to court, and ultimately in that case they actually lost. The court said, listen, this isn't really economic development, this is just you picking a property owner to favor, and that's not a public purpose, and we're not going to allow you to condemn the property. Because when we do actual condemnation, people think, oh, the government can come in and just grab my property. No, in virtually every state, the government has to show a public purpose. And so, the condemning the feed store for a high-rise, that would definitely have a public purpose challenge. If it was just the city would, and that's notwithstanding whether we could do it under our charter amendments and that type of thing. Assuming that we could, for purposes of this discussion, you're going to have a whole separate public purpose challenge.
You referenced the Fifth Amendment a couple times. One question I've wondered about, but never had the opportunity overtly to ask someone who's knowledgeable about such things. It says no person shall be denied the right to due process, but it doesn't say what the quality of that due process is. So what is out there that stipulates where the line is in terms of how much due process you have to get before it's reasonable?
Well, the courts in not so much the land use context, but in the criminal context, the Supreme Court has pretty extensively discussed that very question. And what the courts have said is that it has to be meaningful due process. It has to be a realistic opportunity to be heard, to present evidence on your behalf, to cross-examine the evidence from the opposing party, and to have an impartial fact-finding. Okay. And those are all attributes of due process. Now, the last area that kind of comes in to takings is this question of vested rights. Now, what's vested rights? Vested rights is basically when a property owner has relied on governmental action, and as a result of that reliance, expended significant sums of money, and to the point of where their right to develop the property is vested. Now in Colorado, it recognizes common law, which is what I just discussed. Reliance on a governmental action and expenditure of significant sums of money. It also has created a statutory scheme to where you can vest rights. The important thing about vested rights is that when a government, when a property owner gets to the point, for example, of being entitled to a building permit, government cannot go in and suddenly say, we're going to revoke your building permit because we don't like your development. That would be a case of where vested rights would become an issue. Because the courts have said by that point, you've expended extensive sums of money and you've relied on a whole series of governmental actions up to the point of issuance of building permit. And at that point, your rights are vested. That's why you'll see, as we bring you zoning cases and things, we address these issues in the zoning case. People sometimes will say, well, sometimes even a developer will say, well, I'll deal with that down the road in the site plan or at the building permit. It's like, no, you won't, because when you get to that point, we now have a vested rights issue. we have to deal with those things early on. So that really covers vested rights. Now, people, it can be a landowner who can have vested rights, but adjacent property owners don't have a vested right in the zoning of the property. Only the landowner would have that kind of.
This actually usually you get that a lot on view corridors where somebody wants to put up a second story and they're messing up somebody's view corridor, but they don't have any right to interfere with that.
They don't have a right unless sometimes you will see zoning cases or you will see view easements which are granted. There's actually a case in this city where the view easement is the city shall have an uninterrupted right to forever view this property from Santa Fe Drive. And it's like, that's a very interesting view easement, an uninterrupted forever right to view this property. Now what happens if the property burns to the ground? Does that mean we can make the property owner rebuild it? I don't think so. But, and sometimes these easements and these rights are not really well thought out. So that covers the second part of this presentation. And again, we are going to move on to the last piece of this, which is a very quick discussion of Robert's Rules. And let's just see if, okay, and right here. And so let's talk very, very quickly about Robert's Rules. Again, leave it up to the lawyer not to be able to. Now, Robert's Rules are only important because the city's legislative rules say if there is something that's not addressed, you can look at Robert's Rules of Order as a guide. Now, the city has adopted what we call Bob's Rules of Order. Where do Bob's Rules of Order come from? The Colorado Municipal League, back in 2013, promulgated what they viewed as a model set of rules for local government bodies. It just happened to be written by a gentleman by the name of Bob Widner. Bob is the city attorney in Centennial. Thus, Bob's Rules. Most state government associations have similar things. It's nothing particularly unique to Colorado. If you were to go to Georgia, they have Bob's Rules in Georgia. They have one done for the League of Kansas municipalities, very typical. The idea is, Robert's Rules is about 600 pages. It was written in 1878, and it was really written for large conventions. It really was not written for a local governing body of 7 members. So, it can become very complex. And the idea of doing something like Bob's Rules was to simplify it. Now, there are this is for the city council, but your meetings are very similar. We have to have 4 members to be a quorum. There's a call to order. Now, people say, well, there was no roll call. On many boards, the chair will just ask the clerk to note the roll. The minutes will show the roll, but some boards, the chair will just say, clerk, would you please note the roll for the minutes, and that's fine. Some boards will have an opening statement to attendees just saying, welcome, tonight's the business meeting of the City of Littleton Planning Board, and other boards don't. Again, there's no right or wrong thing there. Public comment, consent agenda, general business, and then in this case it's reports from the mayor or council. In your case it would be reports from the commission and staff, and then ultimately adjournment. Now with public hearings, and this is more detailed addressed in the rules of quasi-judicial proceeding, the public hearing after the staff presentation is opened, and the applicant presents first because the applicant bears the burden. Then there's public comments, the applicant rebuttal, and closing the public hearing. Now the commission can question and discuss the item, but no action is taken until there's a motion. Now, occasionally, I've had one board that, in this city it happened to be, where the board said, well, we don't want to make a motion until we all agree. No, that's not how the process works. It's perfectly all fine that you had tonight a 4-3 vote. That's how the cookie crumbles, so to speak. It's perfectly fine to have a meeting where you don't agree. The purpose of the motion is to bring the item for action, not to somehow try to get to a consensus where everyone agrees. Now, I have occasionally had governing bodies, and this drives the clerk or the secretary of the governing body nuts. The governing body would say, so moved. That's the motion. So moved what? The motion should always be worded, I move that the Bellevue Corridor Plan be continued to June 25th, 2018. Or I move that the Bellevue Corridor Plan be tabled indefinitely. The motion should state what it is. The motion, before it's discussed, has to be seconded. If there's not a second, the motion dies. Now, we use electronic voting. If we didn't have electronic voting, we would use ayes and nays. Now, this has happened. I've even had this happen at the council a couple of times.
Can you go back, please? I'm sorry. Go back. It's one point that I've only seen council do just a couple of times. Call the question. Explain
Yes.
that, please.
What is that? Sometimes there'll be extended debate on a motion. And a member of the body can call the question, which basically then is a request to the chair to call for a vote. Now, the body as a whole can say, well, no, we want to discuss it, and let's vote on calling the question and vote it down and keep on discussing it. And usually it's used in most governing bodies as a way of just saying, okay, everybody, let's wrap this up and get to a vote.
The chair can't unilaterally say, I agree, let's vote.
No, you can't. I mean, you can say, I call the question, and if the body says, I want to continue discussing it, then what there'll be is, there'll be a motion to overrule the chair and continue the discussion. Now, this actually happened with the governing body. In the city, we had 2 motions made at the same time. You can't do that. You get 1 motion, and only 1 motion gets considered. Somebody would say, well, I want to amend the motion. Well, the way this is done, the motion is made, seconded. Now, an amendment can be entertained. If there's an amendment, we vote on the amendment first. If the amendment passes, then we vote on the original motion as amended. If the amendment fails, then it's back to the original motion. Now, motions can be amended by the member who made the motion before the vote, but it must be seconded. Or it can be amended by any member. Now, one of the other things that doesn't happen with this board, but we had one board that tried to have 2 amendments on the floor at the same time. No, we don't do that. You get, under Robert's rules, 1 amendment at a time. You have to resolve that amendment, and then you can move on to another amendment, but you only get 1 amendment at a time. Now, there are what are called subsidiary motions, is the technical term used in Robert's rules. I think the better term is precedential motions. These are motions that, once they're made, you have to decide those. You don't get to move on to anything else. Either an amendment, a postponement to a date certain, table, point of order, these all have to be decided. And occasionally people will, I've had a couple cases where people will say, well, I move to continue. Now I want to go back and discuss the main motion. No, you move to continue, you have to resolve that motion because it's precedential. Finally, motions to reconsider. Motions to reconsider a little bit of a strange motion, because they can only be made by a person who voted with the majority on the original item. Now, anyone can second, but they have to be made by a person who voted with the majority. They can be made during the same meeting before the adjournment, but they have to be addressed by the next scheduled meeting. They can't be made, 6 months have gone by, we want to reconsider. Can't do that.
So if you have two cases in the same meeting, you could bring it up after the other two cases.
Yes.
It's still the same meeting.
Yes, it's still the same meeting. You could say, that first case we decided, maybe we need to go back and reconsider that. Is there anyone here, as the chair, I'm going to go back to that case and see if anyone would like to make a motion to reconsider.
But it has to be someone who voted in the majority. Right.
Yes. A person in the minority can't make the motion. And with that, that covers Robert's rules. Now, there are lots of other little idiosyncrasies in Robert's rules. For example, this occasionally comes up. If you read Robert's rules, it technically requires a vote to adjourn. Virtually every governing body and 4 states I've represented have all dispensed with that and said the chair can simply adjourn the meeting. And that was done at a time when Robert's Rules was written. One of the primary things it was designed to be used for was by political conventions. And actually in political conventions, adjourning the meeting can be a big deal. That's the reason for the vote. And with that, I want to appreciate the opportunity to come here tonight and talk about these things. At any time, of course, we're happy to address any legal issues that you might have.
So we have one addition to that. We actually have the Planning Commissioner's Guide to the Planning Commission, so we're going to hand out some new thank you, Steve, for that. And then the next... We'll be taking after the...
Photo ops afterwards?
Right. That's all we had. I did have one additional thing to... and I didn't ask you about this, Mark, ahead of time, but I did want to introduce you. We don't have enough? Okay, I have another one.
Yeah, I do too. Yeah.
We've got more, so don't worry, that just doesn't mean, apparently I can't count.
I'm sorry.
I'll work on that. We want to quickly introduce you to some of our new staff members. So we have a couple new planners that I've asked to sit up at the table. And if you're okay with this, could we just do a quick around, introduce yourselves, and then I'll have them introduce themselves and maybe how long they've been here. That's all right? Is that all right? Sure. Okay.
Jason Reynolds, live in District 2.
Craig Coronado just rejoined the Planning Commission after several years off. I'm a landscape architect.
John Breinbach.
Robin Schwartzbecker.
Bruce Stallman.
Mark Rudnicki, District 2, and architect.
Sherry Allman. I'm a newbie.
Dave Bolt.
I'm Rob Haig. It's nice to meet you all. I've been with the City of Littleton for about 2 months and a week now, so but glad to be here.
Carl Onsager, this is my 3rd week. Recent graduate.
We're excited. I just wanted to make sure you met them. It's really great to have them on board, and we have still have a sizable workload, but appreciate all the efforts that they're helping dive into, and especially with us having the planning manager now being, but we're working through recruitment on that as well. So
Will I see these guys down in the pit?
You may, yes, from time to time, absolutely, yep.
Yes, the lion's den, okay.
Welcome.
Be prepared.
Thank you. Yeah, always.
I think we're already keeping you busy.
So Dennis is officially...
Oh, yes, and Dennis's last day was last week, so we're also recruiting for that position as well.
How many positions you have open there?
Planning, we have 2. Yep, so planning manager and the senior planner.
Okay, I did. We are adjourned. Unilaterally, I can do that.